And since our last roundtable, there's been a small update in that arena. So last week, a federal court in Texas actually ruled that the federal government's moratorium on evictions is unconstitutional. So the court stated that the individual states have the power and authority to enforce such a moratorium, but the federal government doesn't have that power. So that was a district court in Texas, so that is not binding on the state of Florida. However, I expect the next step is that that would go up to the Supreme Court. If the Supreme Court agrees, that would be binding on all states. So that doesn't necessarily mean that the moratorium is going away. It just means that each individual state would have the authority to dictate how that particular state is going to handle it. So the governor of Florida would be able to make that call, which means for us probably either no moratorium or a slightly less restrictive one. So I will continue to keep an eye on that and keep you guys updated, but that's what we have so far, still kind of in limbo at this point. But the topic I wanted to discuss today was sellers' disclosures. I talk about these a lot, and the reason for that is because I get these questions a lot in my office. There seems to be a lot of misinformation about this topic, and I also seem to have a steady stream of litigation cases relating to sellers' disclosures. So obviously that's something that we want to avoid. So my goal and the purpose of these things is to educate you, make sure that you are informed of the latest in this area, and you're able to advise your clients properly when it comes to these sorts of things. So generally speaking, based on the feedback that I get and the questions from buyers that I get, most buyers assume that a seller is going to disclose to them anything that's wrong with the property. So they're going to have their inspection done, but that coupled with the seller disclosing to them anything else that's wrong is all they really need to do. And that's not true. So legally, a seller only has to disclose certain types of defects under certain situations. And there are 4 elements that must be present before a seller has a legal duty to disclose anything with regard to the property. So I'm going to go through those 4 elements. If you have questions, feel free to jump in and interrupt me anytime. So the first one is that the seller must have knowledge of the defect. That sounds very obvious and very basic, but this standard is a standard of actual knowledge. So in law, there's something called constructive knowledge and something called actual knowledge. Constructive knowledge is something that can be imputed to a person from someone else. So an example of that would be if a seller hires a contractor to do work on the property and the contractor discovers a defect, constructive knowledge would say that that knowledge is imputed from the contractor to the seller because the contractor is the seller's agent. For purposes of disclosing a defect, that's not good enough. We have to be able to prove that the seller had actual knowledge, that that contractor actually told or provided a written report to the seller disclosing that defect. This is usually the hardest element to prove. Because unless you have some sort of smoking gun document, like, a text message from the seller saying, oh my gosh, I got to paint over all this mold before I list my house, which usually doesn't exist, it could be a difficult element to prove, especially when we're talking about flippers and investors and sellers who have never actually personally occupied a property. This can be sometimes a difficult element to prove, but the first element is that the seller must have actual knowledge of the defect. The second element is that the buyer cannot have knowledge of the defect. Again, this might sound obvious, but what this means is that if any time prior to closing on the purchase of the property, the buyer acquires knowledge of a particular defect, at that point, the seller has no duty to make any sort of disclosures. The buyer's remedy at that point would be to refuse to close if it were that significant of an issue. This means that if there's any sort of defect that is disclosed in the inspection report, that's knowledge on the part of the buyer. They would have no recourse if they closed on the purchase of the home and they wanted to go after the seller for certain repairs, they would have no recourse to do that. So buyer cannot have any knowledge by any source, whether it be from the seller or some other source, of the defect in order for the seller to have a legal duty to disclose that defect. The third requirement is that the defect cannot be what's called open and obvious. It has to be a hidden defect. So what this means is that if you're walking through the property and you can see the defect with the naked eye, that's open and obvious, and a seller has no duty to disclose that defect. If the defect is discovered by the home inspector and it's part of the inspection report, that's open and obvious. There's no duty to disclose that. The one that gets a lot of people is that if the defect is discoverable by review of the public record, it is open and obvious. So if there was a sinkhole property and there was a permit pulled for sinkhole remediation, that permit is public record. So the fact that it's a sinkhole property that had subsequent remediation done is public knowledge. The seller does not have to disclose that because it's an open and obvious defect. When we're talking about a seller's duty to disclose. So anything, easements, boundary disputes, encroachments, all of those sorts of things are going to be part of the public record. So it's very important for buyers and buyers agents to know that this is part of the due diligence that they need to perform prior to letting that inspection period expire to where they're bound to close on the purchase of the property. So I see a chat here, Kelly saying, well, I thought sinkhole repair had to be disclosed. If it's part of the public record, it does not, because it's open and obvious. So I would imagine most often there's a permit pulled for sinkhole remediation if it's done properly. And if in your county, which in our surrounding counties, permits are made public, if those are part of the public record and can be discovered, they do not have to be disclosed. Now, if we're talking about sinkhole activity, where there's no remediation done, there's nothing in the public record that would alert a buyer that there's a sinkhole, yes, that would have to be disclosed, assuming all of the other elements are met. So that open and obvious one does get a lot of people, and the area that I see it happening the most is when a defect is apparent from review of the public record. So there is an element of due diligence that buyers and their agents need to do above and beyond just hiring an inspection company and calling it a day. They need to make sure that they're looking at these things. Another thing that comes up often is, let's say the sellers disclose a leak in a portion of the property that was repaired. The seller is not aware of any mold growth, but there was a leak, it was repaired, and so they've disclosed that as part of the seller's disclosures. The onus is on the buyer at that point, if they want to have that area tested for mold, because if they close on the property and 6 months later mold starts seeping through the drywall, the buyer has no claim for that because they were informed of the fact that there was water intrusion, there was standing water for a certain period of time in that area of the property, and so the burden is on them to rule out the possibility of mold prior to the expiration of their inspection period, if that's something that is of importance to them. If they wouldn't purchase the property if there's mold there, that's something they need to verify before they're bound to close on the purchase of that property. Bethany has asked in the comment section, does that apply to adjacent properties as well? So with regard to sinkholes, it does apply to properties that are immediately adjacent to the property in question. Beyond that, no. And we kind of get into a little bit of a gray area here, but I'll go back to, if it's part of the public record, it does not have to be disclosed by the seller. If there's sinkhole activity or an unrepaired sinkhole that's not recorded in the public record via permit or anything else, then that does have to be disclosed by a seller if that seller has actual knowledge of the sinkhole activity. Okay, so our fourth element is that the defect must have a material effect on the value of the home before a seller has a burden or an obligation to disclose that defect. So this is kind of a subjective one. It's going to differ based on the value of the home that we're talking about. So if we're talking about $1 million home versus a $100,000 home, what has a material effect on that value is going to look like a different number, is going to be a different number. So, but basically this element is just stating that it has to be a significant defect. The repair cost has to be significant, or it has to be something that the buyer now has to disclose when they go to sell the home, and they're going to have to settle for a lower purchase price now because of this issue. Those are examples of when it would have a material effect on the value of the home, of course, with that value, that dollar amount differing based on the value of the property. So those are your four elements. We have the seller must have knowledge of the defect. The buyer cannot have knowledge of the defect. The defect must not be open and obvious, and the defect must have a material effect on the value of the home. If all four of those elements are present, the seller must disclose the defect. If any one of those elements are missing, the seller is under no obligation to disclose it. Now, that doesn't mean that the seller can misrepresent things. A failure to disclose is different from misrepresentation. So if they're marking on their seller's disclosure form that the property has never suffered from water intrusion, when it in fact has, that's a different story. But as far as a seller's duty to disclose, you must have all of those four elements present, or the seller has no duty to disclose that particular defect. So at this point, I'm happy to take questions on this topic. I know that was a lot of general information, and there's a lot of specific situations that we can discuss that maybe fall in some of the gray area with some of these, or if you have any other questions regarding anything you come across in your legal in your real estate practice, I'm happy to answer all of those. They don't have to be related to sellers' disclosures at all. So let me know what questions you have for me. Feel free to put them in the chat, or you can unmute yourself and just shout them out whenever they come up.
I have a question.
Sure.
Can a seller simply just say they do not occupy the property and they know nothing, and that's it, and just leave it at that?
Okay, so this comes up a lot when we're talking about investors, flippers, sellers who have never personally occupied the home. A lot of times you will come across addenda to the contract that state, you know, I've never lived here, I don't know anything, so it's as is, and I have no knowledge of any defects. A seller can say that. However, if those four elements are still met, a seller still has a duty to disclose. So if a seller is stating, you know, I've had tenants in the property, I've never lived there, I know nothing. If they've had a tenant in the property that has called them and say, hey, the bathroom is leaking, can you get someone out here to fix it? At that point, they have knowledge. The buyer has no knowledge. It's not part of public record. And if it has a material effect on the value of the home, the seller has a duty to disclose that, whether they've lived there or not. So the fact that a seller has never physically occupied the property does not remove any duty they have to disclose defects if they have actual knowledge and all of the other elements are met. I see investors doing that a lot, where they just make this broad statement, I know nothing, but that doesn't fly if they actually do obtain knowledge of the defect. And a lot of times this comes up too with bank-owned properties after foreclosures. So the assumption is the bank knows nothing about the condition of the property. They haven't occupied it. They've probably never seen it. They don't know what it looks like. However, you will often, in the midst of foreclosure actions, have borrowers who call the mortgage company and say, you know, the roof is caving in, I'm not paying my mortgage, I need insurance to pay this before I can make a payment, will you work with me? And by that phone call, which if it's to a big bank, it's usually recorded, the bank is acquiring knowledge of certain aspects of that condition, of the condition of that property. So the short answer is it doesn't matter whether you've lived there or not. If you acquire knowledge and all of the other elements are met, you do have a duty to disclose those things. So Kelly's asking here in the comments, so what about a hole in the floor covered by a rug until final walkthrough? No disclosure, the hole was under a bed. So again, we have to look at our 4 elements. So typically an inspector is not going to move things like furniture, appliances. They may pick up an area rug, they may not. But if there is a defect that is hidden under a piece of furniture or behind an appliance, that would be something that is not open and obvious, and a seller would need to disclose. Those sorts of things too, we're going to have to look at, does it have a material effect on the value of the home? You know, a scratch in the hardwood floor is not going to meet that standard. Cosmetic defects are not going to be sufficient to meet the material effect element of seller's disclosure. So if it is hidden by furniture, appliances, something like that, it is a hidden defect and that element is satisfied. So if all of the other elements are satisfied, a seller would need to disclose that. Other questions? So one thing I get asked a lot when it comes to these is, okay, what happens if the buyer does discover a defect in the property prior to closing? What do they do? Legally, their remedy would be not to close. If the buyer goes forward and closes on the property, at that point, they've waived their right to come back later to the seller and complain, well, here was a defect you didn't disclose. I need you to pay for the repair costs or whatever the case may be. Practically speaking, very few buyers want to, refuse to close because of a defect. It's not something significant enough that they want to, forego the property or not close on the property. But that's the decision that they have to make at that time. Another alternative is they can go back to the seller and say, hey, here's this defect. We found it on public record. You never disclosed it. Will you contribute a certain amount toward repair costs? Will you reduce the purchase price? Let's renegotiate these terms so we can salvage the deal. That's an option. The seller has no obligation to renegotiate, but assuming we're still within that inspection period, the buyer can choose not to close. So usually that's enough leverage for a seller to at least want to be reasonable and talk about different options to save the deal. But if push comes to shove and the seller's not willing to contribute, the buyer's only remedy is to not close, or if they close, they know that they're going to bear the full cost of making whatever repair is needed for that defect. So we have another question here. What about putting it on the final walkthrough and then closing? So if something is discovered at final walkthrough, which is usually morning of closing, maybe the day before, that is something that can be noted. However, if the buyer wants the seller to contribute to any sort of repair costs, that agreement needs to be made prior to the closing documents being signed. Once a buyer closes, they can ask the seller to contribute, but they have no leverage to force the seller to. Legally, the seller's not required to contribute anything. The buyer's remedy is to not close. This also comes up when, the buyer inspects the property at the beginning of the contract period, and then at final walkthrough, something has changed. The refrigerator's missing. Mold started to seep through. There's a change in the condition of the property between contract signing and final walkthrough at closing. That is a breach of contract by the seller. The seller has to maintain the property in the same condition it was when the contract was signed through the closing. So at that point, the seller would have a legal obligation to restore the property back to the condition it was when the contract is signed. But if we're just talking about a defect where there was no duty to disclose, if the buyer wants anything from the seller, my advice would be to negotiate that before signing any closing documents. Okay, so another question here. So if the buyer finds something on the public record outside of the inspection period, if they cancel due to finding that, does the seller get to keep the earnest money deposit? Yes. So if the buyer discovers a defect by reviewing the public record after expiration of their inspection period, they cannot cancel the contract and get their deposit back based on the discovery of that defect. Presumably that defect could have been discovered on day one, and because the buyer didn't look for it on day one is the only reason why it wasn't discovered. So in this scenario, yes, the seller would be entitled to keep the earnest money deposit if the buyer canceled outside of the inspection period on this basis. The burden is pretty high on buyers to do their due diligence, and I almost think it's an unrealistic burden, which is why I work so hard to try and educate you agents that are representing these buyers, because you know, the typical home buyer, whether they've bought several homes or it's their first time, they're not going to know that they have to go through all of these steps in order to make sure that they're protected, that, you know, they're doing the due diligence that is required of them legally to uncover any of these defects. It's not something that, you know, the general population is aware that they even need to do. So that's why it's important that you know, so that you can advise them properly.
I have two questions.
Sure.
So the first one would be, can you please go over what the repercussion would be for a seller who does know a defect but they don't disclose it? And then the second question would be, on the first requirement you mentioned about the seller must have knowledge of the defect. What do we need, even as a seller's agent, to prove that the seller did know the property had that specific defect?
Okay, so the first question is, what is the buyer's remedies if the seller didn't disclose something that they were required to disclose and that is discovered after closing? So from a legal standpoint, the seller would be legally responsible for all damages that the buyer has suffered as a result of that failure to disclose. So number one would be, the most obvious one would be any repair costs. So what is it going to cost the buyer to repair, whether the buyer's already made the repair or where the buyer has a quote to make that repair in the future? The cost of making that repair would be part of the damages suffered by the buyer. If it's also something that the buyer now has to disclose when they sell the property, and we can show that the property is actually worth less now with that disclosure, that is also part of their damages. That's a little bit more involved. We'd have to get an expert to appraise the property without knowledge of this defect, and then appraise it with this defect disclosed. And if there is a difference in those two appraisals, the seller would be responsible for that difference. Usually, you know, when I get these cases, I start off by just reaching out to the seller saying, hey, here's what was discovered. Here's what it's going to cost to fix it. Will you reimburse them the cost or not? If not, and we can't come to some sort of amicable resolution on that issue, the buyer's remedy would be to file a lawsuit against the seller to recover these costs. So it would have to be recoverable damages, things like, you know, stress and, you know, emotional distress, time off of work. Those items generally are not recoverable in this type of situation. It's going to be generally the cost of repairs and any reduction in value of the property as a result of this issue. So the second question was, what do we need to prove that a seller has actual knowledge of a defect? Like I said before, this is one of the most difficult elements to prove, but proof of this can come in several different forms. You can have, you know, I've had cases where neighbors have said, oh yeah, the lake behind that house, when there's a bad storm, it rises up so far and the whole back of the house is underwater every time it rains. So sometimes neighbors know, sometimes neighbors have the same issue with their property. So they know. A lot of times the seller has had work done and the contractor finds the defect and it's part of an invoice or a report that the contractor provides to the seller. Sometimes a seller is, you know, texting with their husband like, oh my gosh, we got to get someone out here to paint the ceiling because the water spot's showing through. It could be a variety of different things. to show that a seller has knowledge. You would be surprised at the silly thing. I mean, Facebook posts like, oh, I'm stuck at home today because I have these people coming over to dry up a leak that I had in my bathroom. I mean, silly things sometimes will reveal knowledge that a seller has about a defect without them even realizing that, you know, that's what they're setting up in the process. But a lot of times it's going to be neighbors or somebody who the seller has talked to about the defect, or it's going to come from a repair or a contractor doing work or giving an estimate, even if the work is never done, are the most common ways that we prove a seller's knowledge. Okay, hopefully that answered your questions. If you have follow-ups on that, let me know. I think there's another question in the chat. Let me see. If the buyer finds something after closing and they think the seller didn't disclose, is the burden on the buyer to prove that the sellers had knowledge of the defect? The answer is yes. So if we're in a situation where a buyer has a legal claim against a seller for a defect that was not disclosed, since it's the buyer's claim, the burden is on the buyer to prove that all four of those elements exist. So the buyer would have to prove in court that the seller had knowledge, the buyer did not have knowledge, it was a hidden defect, and it had a material effect on the value of the home. So yes, that burden would be on the buyer to show those things. All right, any other questions for me? I know that this seller's disclosures topic is a popular one, and I'm happy to talk about it for the entire time that we have this morning. But if you have questions on other topics, feel free to ask those as well.
How many years after the closing do buyers have in order to go after the seller if they discover damages to the property?
Good question. So I'll kind of give two answers here. So legally, there's a statute of limitations, which is a time period that anybody has to file a claim before it's waived, before it expires. So a seller's disclosure case is typically going to be a breach of contract. There's language in the FAR contract that says the seller has to disclose these things with these elements. So a breach of contract is going to have a 5-year statute of limitations. However, when that statute of limitations starts to run can be different. So in this case, it would be when the damages are discovered or realized by the buyer. So it's not when the contract was signed, it's not when the closing happened, it's when the buyer discovered that there's a defect that was not disclosed is when that time clock would start to run. Now, just because you have 5 years to file a claim doesn't mean you should wait that long, because with issues like this, let's take mold, for example. Let's say, you know, a month after closing, mold starts seeping through the walls, and come to find out the seller knew about a leak that they didn't disclose, and the seller's on the hook. If the buyer waits 2 years to file a claim, legally they're still within their time period, but if they have not remediated the mold and that mold has continued to grow and pollute the air and spread to other areas of the property, they're not going to be able to recover for the damages that they have now 2 years later, because they've let it sit there and get worse and worse and worse and worse and worse. So practically speaking, either the buyer needs to make the repair as soon as they realize it, or they need to file the lawsuit within a reasonable time after. You know, typically they find the defect, they say, oh no, let me call someone and see what it's going to cost. Oh my gosh, it's going to cost me 20 grand. All right, let me call a lawyer and reach out to the seller. So there's some steps that happen before practically we can file a lawsuit. But I wouldn't recommend waiting an extraordinary amount of time to where the damages are getting worse and worse and worse, because the buyer's not going to be able to recover for any increase in damages due to them sitting around and doing nothing, if that makes sense. So it's called a duty to mitigate damages. So, you know, as a plaintiff, as someone who's filing a lawsuit, you have a duty to mitigate your damages, which means you can't just let it sit there and get worse and then 3 years later say, oh, now I want my whole property remediated with mold because it's continued to grow throughout the years. So that was a long answer to what seemed like a very simple question, but legally you have 5 years. Practically, you probably want to do it pretty soon after you discover the damages.
I have another question.
Mhm.
So what if the case, what would happen, like, for example, if you have an investor who like flipped a property, right? And they put in like super cheap material, or the contractors didn't really do like quality work. So technically there weren't damages per se when they sold the property, but let's say like 2 years later, the buyer is having like the siding of their house needing to be repaired just because the investor chose like the cheapest material and low quality work. Would the buyer be able to file a claim against the seller in this situation?
So if we're talking about kind of just using cheap materials that aren't going to last, I don't think there would be a claim there, because for the siding example, that's something that's open and obvious. The buyer's inspector can see it, can examine it, can look at it, see what type of quality it is prior to closing. So if it's just like normal wear and tear, that's going to happen faster because cheap materials were used. I don't think there would be a claim there. I had actually a recent case in my office where this was a flipper situation, and there was aluminum wiring throughout the property, which was not up to electrical code. And what the flippers did was, instead of rewiring the entire property, they changed the wiring from the main breaker box and in all the outlets, so that if the inspector looked behind the outlets, you wouldn't see aluminum wiring. When you're looking at the breaker box, you don't see aluminum wiring, but they didn't change. So that is something that they knew was present, that they didn't disclose, that the buyer would have no way of knowing. There's a claim for failure to disclose. But if we're just using kind of subpar materials, I don't think you would have a claim there.
I had a question from an agent today who asked, you know how oftentimes like a little bit of mold will, or black stuff will grow on the handler of the AC in the garage. So he's cleaning it off before they list it. Is that something they should list on their disclosure?
We're getting kind of gray here, but so, yeah. I mean, if it's just from the normal condensation that happens with AC units, no. If there was a leak in the unit, and the mold growth was result of the leak not being repaired timely, then I would say yes. The AC is something that an inspector is going to look at. If the inspector sees anything, and notes anything out of the ordinary or that's unsatisfactory on that inspection report, I would recommend that the buyer get an AC contractor to come out and do a specific inspection of the AC unit. But I don't think that a seller would be on the hook for, you know, concealing a defect or trying to cover something up by cleaning the mold off and not disclosing, so long as there was no leak, the AC is working properly, there's nothing wrong. I mean, mold in Florida is sometimes a difficult case to make because you don't have to have a leak or a water intrusion event to have mold in your house in Florida. And when we're looking at those types of cases, we have to prove that the mold was a result of the leak and was not the result of, I keep my AC at 80 degrees and it's humid in Florida, which takes expert testimony and things like that. So in that case, I don't think there's need to worry from the seller standpoint or need to disclose anything because there's no actual defect. I think, you know, all buyers in Florida are imputed with the knowledge that mold is possible in Florida no matter what. So just the presence of a little bit of mold on the handler is not going to be a defect that needs to be disclosed.
Thank you.
You're welcome. All right, any other questions?
So basically, any repairs done on your property have to always be disclosed on your seller's disclosures, correct? Like say there was a leak under your kitchen sink and it caused like a little bit of mold to grow, but you fixed it, was taken care of, and it's no longer growing. Obviously that would need to be disclosed, correct?
So the answer on that one is it depends. So if you, well, first of all, we have to look at the language of the seller's disclosures. So I'm not quoting here, but I believe the language is, has water intrusion ever affected the property? Based on what you just told me, the answer in this situation would be yes. However, if there is a small leak, no standing water, you caught it right away, and you rip open the walls, you test for mold, you completely remediate everything, no need to disclose. But if you just dry up the leak and dry up the water and fix the leak, and you don't test for mold, you don't know if there's mold, I would disclose that, because sometimes mold takes a while to grow and to actually seep through the walls or whatever the case may be. So if, you know, 2 years down the road after the buyer has purchased, mold starts coming through the drywall and there was a leak that wasn't disclosed, the seller could be on the hook. So I think it depends on what the issue is. I also think it depends on, you know, the repair that was done. If you just fixed the leak and dried up the water, I would disclose it because you know there's a potential for more. If you have, you know, like I said, cut out the walls and completely eliminated the possibility of any mold, not necessarily, but I do still think the questions on the seller's disclosures need to be answered honestly. So if the question states, has there ever been water intrusion? Yes, you know, bathroom leak 2018 repaired, you know, and that puts the burden on the buyer now to do their due diligence. So the buyer now has the burden to test for mold if they want to. The buyer has the burden to say, hey, let me see the receipts from that repair. Let me see exactly what was done to make sure it was done by a licensed contractor. You know, if there were permits required to be pulled, were they pulled and closed out properly? That shifts the burden all onto the buyer, which is a good thing for the seller. So, you know, a lot of times sellers don't want to disclose things because they're afraid, you know, the sale's going to fall through, they're going to get a lesser amount for the property. But for things like this, it's better for them to disclose because now the burden is totally shifted on the buyer to do all of their investigation and due diligence as far as any issues that could arise as a result of that previous issue. So that was a long way of saying it depends.
Yeah, that's good.
All right, we have time for some more questions, but while we kind of have a pause here, I'll go ahead. Stephanie has put in the chat for everybody the link to register for next month's event. The topic I'm going to be discussing is a comparison of the FAR/BAR contracts with the CRISP contract. I know the CRISP contract doesn't come up often, but I also know that there are certain agents out there that demand that the CRISP contract be used in order for their clients to consider any offers. And so it is important as agents for you to be at least familiar with these contracts. There are some important differences between the two and, you know, why I would recommend using one or the other, pros and cons between the two. So I will be discussing that at our next month's event, which is going to be April 7th, same time, 10:30 via Zoom. If you have suggestions for topics that you want me to speak on, my goal is to talk about topics and educate you on things that interest you on issues that you're seeing out in the field. So you're going to know what those things are way better than I will. So please let me know if there's a topic you want me to talk on. I promise you I will make it the topic of one of our monthly roundtables. But I'm always open to those ideas and looking to see what questions you're getting, what issues you're seeing in the field on a day-to-day basis. So that feedback would be extremely helpful. So you can register at the same place for next month. I hope to see you all. Feel free to forward this to other agents in your brokerages and your contacts. I would greatly appreciate that. But we do have time for more questions. So I just wanted to take a short break to let you know that that information is in the chat there for you.
You do? No, go ahead.
I do have another question.
Okay.
As far as giving a seller the property disclosure to fill out, as an agent, we're not supposed to take any part in that. So how, I mean, it's up to the seller to fill it out to the best of their knowledge, but do we advise them? We're not supposed to advise them on how to fill out the property disclosure.
So as an agent, you're not allowed to give legal advice. So you're kind of walking a fine line in this context. I would recommend to sellers that you represent that they do fill out the disclosures. I think those protect both the seller and the buyer. A lot of times with seller disclosure issues, of course we have the cases where the sellers are purposely trying to conceal an issue or trying to pull a fast one on a buyer. We do have those cases, but a lot of times the seller just forgot, or it was just an innocent mistake. There was a roof leak 5 years ago that they had repaired that they forgot even happened. So having them go through those sellers disclosures kind of works to jog their memory, and it also lets them know what types of things need to be disclosed. So I would definitely have them fill one out. It's not required. I do get that question sometimes from buyers agents. It's not required, but I do think it protects both parties. What you cannot do as an agent, you cannot give the presentation I just gave. You can't say, well, legally, if these 4 elements are met, you have a legal, duty to disclose these things, and if you don't disclose them, then you're going to get sued and you're going to be responsible for repair costs and for decrease in property value. You can't advise them on their legal obligations. You cannot advise them on what will happen if. That is legal advice. So if they have those questions, your go-to answer, and I recommend you do it or at least confirm it in writing, is, here's the disclosures. I recommend you fill it out to the best of your ability. If you have specific questions on what you're supposed to disclose and what you're not, I recommend you talk to a lawyer. That's going to cover yourself. And also, it's probably not a bad idea for them to talk to a lawyer if there's a specific scenario that they're not sure whether they need to disclose or not. What I would say is, if in doubt, disclose. You can advise them of that. If they're, not sure, I would always err on the side of disclosing it. You can point them to, the contract language. I think it's paragraph 10J of the FAR contract that has their duty to disclose, and let them read that. But you can't, kind of tell them when they're legally required to disclose and what the repercussions could be if they fail to disclose. That would constitute legal advice.
So if I, as an agent, and going back to the example of the aluminum wire, the flipped house, as an agent, if I knew that there was aluminum wire in that house, and they didn't disclose that on the disclosure, I still, as the agent, need to disclose that.
Yes. So as an agent, you have a separate duty, separate and apart from the seller, to disclose those issues. So if you know that your seller is misrepresenting something on the seller's disclosures, you need to tell your seller, hey, I have a duty to, to accurately disclose this item. So I suggest you go ahead and accurately disclose it. You also have a duty to disclose an issue that the seller's just leaving out, that they're just not disclosing at all. They're not misrepresenting, but they're not disclosing it. So in that case, if you as the agent knew there was aluminum wiring that was not repaired, and the seller went and repaired, you know, the wiring behind all of the outlets in order to conceal that, that would be something that ethically you would be obligated to disclose from like a FREC ethical licensing standpoint.
Yeah.
So back to the question about the seller saying they never lived in the house. I just happened to look at a disclosure that was attached to the property I'm going to look at, and the disclosure, it's not a typical disclosure, it's just a disclosure saying that the owner never lived in the house and that the buyer is agreeing that they have to rely on the inspection for anything. That the seller is not disclosing anything and the buyer has to is agreeing to just rely on the inspection. Is that, I guess I would say to the buyer, you know, it's up to you if you need to want to sign that or not, but can the seller still later on say, no, you signed this piece of paper saying you were relying on the inspection when you find out that there's a sinkhole activity that they know about?
So with regard to these addenda, I've seen a lot of them, and they're usually not professionally drafted. So I have seen some that have been upheld in court and enforceable, and some that have not. So in an addenda, a seller can say, I've never lived here, I don't have any knowledge. Buyer hereby agrees to rely solely on his or her own inspections and walkthrough, and viewing of the property. Seller is relinquishing any right or any obligation or duty that it has to disclose under Johnson v. Davis. So buyer is agreeing that seller is under no duty to disclose. If that specific language is there, that is enforceable, and seller doesn't have a duty to disclose, even if we have all four elements present. That doesn't mean that a seller can conceal defects or misrepresent a defect, but it just means that if there's a defect present, even if it meets those four elements, a seller doesn't have to disclose it. If that specific language is not there and the buyer is not being put on notice that the normal seller's duty to disclose is not applicable here, that part is being stricken from the contract, that is enforceable as a waiver of any duty to disclose. But the language has to be very specific. If a seller's just saying, I haven't lived here, I don't know anything, it's as is, buyers buying at their own risk, that is not good enough. If there is a defect that meets all four elements, the seller still has a duty to disclose it. I hope that difference was clear there. If not, I can try and explain it a little bit better.
It does, thank you.
Okay.
So we have Bethany asked a question in the chat, and I will make this our last question since it's now about 11:20.
Okay, so Bethany's saying, as listing agents, we are advised to not have the buyers send the inspection report if they're canceling. But if it can be found on an inspection, is the seller or I required to disclose what is on that report? Okay, so there's an issue that comes up in a transaction that doesn't make it to closing. So buyer has an inspection, they cancel within the inspection period, and they send that inspection report either to the seller's agent or to the seller. Most sellers don't want to receive that information because at that point, they now have knowledge of everything in the inspection report, and that could lead to a duty to disclose. Now, when you really think about the defects that would have to be disclosed in this situation, because they've now seen this inspection report, it's very limited, because if you recall, The defect cannot be open and obvious, which means that a normal inspection is not going to uncover a hidden defect because it's hidden. So if an inspection report is uncovering it, it's probably open and obvious anyway. Now, there are instances where an inspector might move the refrigerator away from the wall and look behind it. Most inspectors don't do that. If you happen to have an overly thorough inspector that has found something that a typical inspector wouldn't, that's where there's an issue created, because now the seller has knowledge of something that they didn't have knowledge of otherwise that they have to disclose. So if the inspection report is sent to you as the listing agent and your client, the seller's like, I don't want to see it, don't send it to me, I don't want it, you still have that knowledge as the listing agent, and you now have a duty to make those disclosures. So if it's emailed, that's a tough one to get around because you can't not accept it. So that would be something that, you know, you would have to communicate up front is, you know, we don't want copies of anything. That's your inspection, you paid for it, we don't want it. If they send it to you as the agent, you now have knowledge. I've had sellers switch agents because of that. Well, you now have to disclose it, but if I let my listing agreement run out and I go list with this agent over here, now nobody has to disclose it because nobody knows, assuming you didn't tell your client. So there's a lot of kind of nuances that go in with that one, but the short answer is as a listing agent, if you acquire knowledge, however you acquire that knowledge, the duty does arise that you disclose it, again, if it meets those 4 elements.
Okay. So.
Thank you guys so much. Your questions were awesome today. I love doing these. I love educating, first of all, but you guys also keep me on my toes and you kind of give me some better insight as to what you're seeing every day out there in the field with your buyers and sellers. So thank you so much. Again, please, Stephanie put her email up there. Please email her with any topic ideas that you have for next month or any following months. I would love to speak on what you want to hear about. That's the point of all of this. I also want to mention, I forgot in the beginning, that I give free 15-minute consultations to all real estate agents. So if you have a question on behalf of one of your clients and you're not sure if a formal consultation is needed or if I could even help at all, send me an email, give us a call. There's no charge to you to ask those questions. Even if it's something as simple as, you know, creating an addendum and you're not sure about the language or what it should say, I'm happy to give you my feedback and to answer your questions on those. So please utilize that. I'd rather you contact me with something like that instead of, oh my gosh, I'm in a mess, what do I do, sort of thing. So please utilize that. I hope to see you all next month. And again, thank you so much for attending.
Thank you.
You're very welcome.
Thanks, Kristen.
You're welcome.